Good afternoon and welcome to the Appellate Division, First Department. In a moment, I'm about to call the calendar, but before I do, I just want to welcome and acknowledge that we have some interns with us today who will be observing argument, and that is Christopher Andro, who is a first-year law student, and Mr. Onawama, who's an undergraduate here in the city, and I welcome you. Where are you? Okay, welcome. It brings us actually a sense of normalcy, sort of pre-COVID normalcy, because we routinely had visitors and interns who would come and watch oral arguments. That was restricted during COVID, and I believe that you are the first interns that we have had since we changed our procedures during COVID. So it's bringing us back to a sense of normalcy, and we appreciate your being here. Now, on to the calendar. As I call your case, please identify yourself and indicate to me how much argument time you will require today. People versus Aguilar. 6? All right, appellant can have 6 and 2, and respondent can have 6. Thank you, counselors. Beltran versus Campbell. Okay, you can have 5. You don't have even somebody arguing in opposition to you. You'll have 5. I'll give you 5 minutes. Okay. In the matter of Sarah D., you have no respondent, and we are familiar with the issue, so I'll give you 5. Thank you. Lynch versus New York City Civilian Complaint Review Board.
Good afternoon. For appellants, 8 and 2. Your Honors, for respondents, 10, please.
All right, appellant can have 8 and 2, respondent 8. Maldonado versus Baja.
For appellant, Your Honor, 8 and 2. For responding, Your Honor, 4 minutes.
All right, 6 and 2 for appellant, 4 for respondent. People versus Zamil Washington. All right, 5 and 2 for appellant, 5 for respondent. New York City Waterfront versus Puree Battery Park.
Good afternoon, Your Honor. Good afternoon. For respondents, 5 minutes.
All right, appellant, you'll have 6 and 2, and respondent, you'll have 5. People versus Maldonado.
Good afternoon. For appellant, requesting 6 and 2.
Respondent plus 5.
All right, appellant, you'll have 4 and 1, and 4 for respondent. Pianternel versus Smiley and Smiley.
For appellant, could I have 4 and 4? Good afternoon. For respondent, we have 5.
All right, I'll give respondent 5. I'm looking at appellant. Usually I don't give that much time in rebuttal. I'm willing to give you the 8 minutes. I'll give you the 4 and 4, fine. Okay, you have 4 and 4. Okay, Todd English Enterprises versus Hudson Home.
Respondent, 5 minutes.
Appellant, you'll have 6 and 2. Respondent, you'll have 5.
Thank you.
People versus Chadwick. Submit. Simon versus Lewis. There are 3 appeals on the calendar. Submit. Chan versus 907 Corporation. Submit. First case on for argument, People versus Aguilar. Step up, please.
Good afternoon, Your Honors. Jan Hoth for Appellant Gonzalo Aguilar. There is absolutely no support in this record for the court's finding of pretext. Relying on prospective juror Lewis's responses during voir dire, the court simply announced that it found that defense counsel's reasons for challenging him were pretextual.
What was the race-neutral reason given by counsel in this case with respect to Mr. Lewis?
He explained that Juror Lewis was a graduate from Columbia, he was a retired executive from Coca-Cola, and he didn't like his answers. He didn't want him.
So again, what's the race-neutral reason?
I'm sorry?
What is the race-neutral reason? I haven't heard
That
of it.
is race neutral. There's no indication of race in that response at all. The district attorney doesn't even argue that the response was not race neutral, which is...
So wasn't the initial response, so I can't give you any other reason other than I'm satisfied, and it was only later, after further prodding, that he came up with the excuse that you're articulating, or the reason you're articulating?
Well, it was an ongoing conversation, so
Wasn't
yes.
his first and initial response when asked for the race neutral reason, I can't give you any other reason other than I'm satisfied?
That was his initial
Is
response.
that a valid,
And then
is
when...
that a valid race neutral?
But that's not the whole response. We can't just take one sentence out of the entire colloquy that was engaged in. This was a continuing conversation, and when the court specifically said, give me a race-neutral reason,
But didn't he only come up with that after further prodding from the court, and what significance should we give to that?
well, Your Honor, the court said, give me a race-neutral reason. So yes, it was not his initial response, but there was no break in the conversation. It was an ongoing conversation. The court said, I'm finding that a pattern has been established.
And how should we factor into that there had been a number of peremptory challenges already used to exclude Black people from the jury, and that this was one of many that had occurred?
Well, it's actually very interesting because the prosecutor's initial challenge was denied by the court, and it was only to one juror, because if you look at his initial objection was that defense...
That wasn't my question. My question was all of defense counsel's peremptory challenge of Black people on the jury.
I'm sorry, I'm not
My
understanding.
question had to do with the peremptory challenges used by defense counsel, not the prosecutor.
No, that's what I'm saying. The prosecutor was objecting to defense counsel's use of peremptory challenges. He actually inserted a reverse Batson prior to this one, and the court denied it, saying that...
Well, that doesn't really mean much, quite frankly, because, as you indicated, the court was looking for a pattern. Sometimes the pattern is not revealed until further preemptories are exercised. So while the court may find on the first preemptory that there was no Batson challenge, that doesn't mean by the fifth African American who's being challenged or who's being struck from the jury, that there isn't a different record on which the court needs to make a decision about whether this is a legitimate Batson ruling or not. Wouldn't you agree with that?
Yes, but Your Honor, what we have here is, I'm not saying that it's not a factor, but when asked, he was only asked to give reasons for prospective juror Lewis. If we go back, at least 3 of the female Black prospective jurors that were peremptorily struck by defense counsel had family members or were themselves a victim of vicious crimes. They are clearly someone that defense counsel would not want. So even though in this case we're past whether a pattern had been established, the first 3 shouldn't even have been counted. So then when you look at the initial challenge, he was asked for a reason as to one prospective juror. Then we get to the next one, the court found a pattern. We're not arguing
What
that.
evidence was there of actual bias on the part of this juror?
Was there bias on the part?
What evidence was there in the record that this juror would be biased against your client?
Your Honor, there's several reasons why defense counsel might not have wanted him, and for the very reasons that he said. He was a retired executive from Coca-Cola. This was a dispute between a bunch of 20-year-old kids and involved the use of smoking marijuana and ketamine, something that not a lot of people are very familiar with, and that was central to the defense. Obviously, defense counsel could have believed that a retired executive from Coca-Cola who graduated from an Ivy League college would not be able to relate to the defense his client wanted to present, and that was that kids hopped up on pot and ketamine had attacked or exacerbated the altercation that was being had. If you look at the jurors that he did sit, they were younger, they worked with young people, there's clearly a reason why Juror Lewis would, if not biased, certainly not have been a #1 pick for defense counsel, irrespective of whether there was a pattern set. His reasons, and more importantly, there's nothing in this record. We're all extrapolating, we're all hypothesizing. The court said pretextual and nothing else.
Well, we're also looking at the way that the court assessed the credibility of counsel for the defense.
But the court made no finding on credibility. At the initial reverse Batson, he said he found defense counsel credible. At this one, he never mentioned credibility. His decision was limited to the reasons for challenging him are not race neutral, something which is not up for debate on this appeal, and pretextual. That neither the DA or the court ever pointed to another juror that was similarly situated. The court gave no reasons for why it found the reasons proffered to be pretextual. So there's no reason to go that far. We have nothing, there's no support in the record for what the court found at all.
What's the significance? I'm sorry.
Go ahead.
What's the significance that he was a retired executive from Coca-Cola in particular? Everybody keeps saying he was from Coca-Cola.
Well, what I'm saying is that he worked for the management team of Coca-Cola, and Coca-Cola is a Fortune 500 company. So, and again, there's no record, so we're hypothesizing that he's of an age and of experience that was not conducive to understanding what happened here. We had a credibility contest between a group of kids, all in their young 20s, who had been smoking pot, drinking alcohol, and doing ketamine, against my client and his co-defendant, who were also in their young 20s, had been drinking, and an altercation broke out. Who started it? Who escalated it? That was at the heart of this case. So it's not unusual that defense counsel would not want someone with the background of an Ivy League education, management at a Fortune 500 company. Certainly he would want an NYU professor who worked with 20-year-olds, another woman who worked with the players at the WNBA. All of these were jurors who were perfectly positioned to understand what was going on with these young people.
All right, thank you. You'll have time on rebuttal. You may proceed.
Thank you very much, Your Honor. Good afternoon. May it please the court. Stephen Kress on behalf of the people. I think I have to start off by pointing out that defense counsel below never made this argument. I mean, yes, he says that he said that Juror Lewis went to Columbia and went to Coke. Never said, oh, and for those reasons, I think that he wouldn't be able to evaluate a credibility contest between groups of young people. I mean, it just was never below. This is something that's purely concocted by defense counsel on appeal. And I have to say,
why isn't that explanation that the juror works for Coke and went to an Ivy League school, why isn't that enough?
Well, if I can, Your Honor, let me first say, I think it's perfectly fair to question the sincerity of that actual explanation, because it only came after he was getting no traction whatsoever with his actual answer, which was simply, I don't really like him. But let's assume for the moment that he was being sincere in offering those reasons. I think that is rebutted in this case because he left other jurors, or he left other panelists on the jury who shared a similar, yet not identical. We didn't have another person who went to Columbia, another person who went to Coke, but similar means similar, not identical. You had plenty of other college graduates that he decided to leave on the jury, and I don't think it makes one bit of difference whether somebody went to an Ivy League college versus some other college or worked for Coca-Cola as opposed to ABC News, which was the place where another person on this jury worked. Both of those people don't have anything in common with the defendant, who is a high school dropout and not working at that kind of a job. And that was the argument the defense counsel originally made in her opening brief. So the fact that similarly situated jurors were left on the jury, you combine that with striking 5 out of 6 black jurors in a case where the murder victim was black, and you add that with defense.
Also, was it a credibility determination made by the court, or at least implicitly a credibility determination?
I think it was, Your Honor. I think what the Court of Appeals has said is that a pretext finding is a pure question of fact that almost always turns on credibility of the attorney, and particularly the attorney's demeanor, which is something the trial judge has an opportunity to see. And so I think when he says, I find these reasons to be pretextual, he is making a credibility determination. And on that point, defense counsel argues in her brief that, well, you don't have to give a reason that would amount to a challenge for cause, and that's true. But this is ultimately a question of credibility. And the fact that defense counsel said, I don't think that Juror Lewis could be fair and impartial, and then there is absolutely no reason to believe, or nothing that would suggest from any of his answers or anything about him that he couldn't be fair and impartial, that undercuts the credibility of that statement, and it's absolutely relevant to consider. I do also want to speak briefly about the sentence in this case, because the defendant did raise an excessive sentence claim. And in that regard, I would just point out that the word senseless was mentioned a number of times at the sentencing, and I think that that is an apt description of this crime. Brutal might be another one. Callous. Of course, the defendant faced 25 years to life for killing Henry Lane alone. He received 25 years to life for killing Henry Lane and very nearly killing Alan Latkovic. And it's simply by blind luck that he didn't. And I think as the court is considering this claim, I would ask you to recall the defendant's statement to Peter Weeks immediately after this incident. And I won't repeat the incredibly offensive epithets that he used, but he in substance said that these 2 victims got what they deserved. And that is simply not a statement of the sentiment of somebody who's deserving of a sentence reduction. If the court has questions about the other issues, I'm happy to answer them. But otherwise, I would ask that the judgment be affirmed.
Colleagues, any questions? Thank you.
Thank you.
All right, we'll hear rebuttal.
Just 2 quick points. One, my adversary points out that defense counsel did not make the arguments that I'm making on appeal. But equally, the trial assistant below never pointed out a similarly situated juror, just merely made the statement that there were similarly situated jurors. To uphold this grant of a Batson, this court must be able to look at a record that supports it. And there is absolutely no factual basis.
Didn't the court make a credibility determination? Because as my colleague brought out earlier, his first explanation was, I'm just not satisfied. And then after a lot of back and forth, he came up with more explanations. Couldn't the court have just made a credibility determination, not accepting, in light of what happened with respect to other jurors, statements made by defense counsel?
So basically, what that argument means is that by simply finding pretext, the court was finding that defense counsel was not credible. I mean, that's basically what you're saying, because the court never said that he wasn't credible. All the court said was pretext. And my argument is that's not enough. What we're doing now is we're all looking at the record and we're all making our arguments based on what we see in the record. But there was no record made by the trial assistant, nor was there any record made by the court to support its decision. So to say that the court found defense counsel incredible is to say a finding of pretext equals incredibility. And I don't think that's what the law is. I think the law is very clear that we need to be able to look at the record as made. And there is no factual basis given to us. And if we look, there are no similarly situated jurors. They're just not. I mean, a juror who works with players at the NBA is not similarly situated with a retired executive from Coca-Cola, regardless of the fact that they both graduated college and work for large organizations. And that is my adversary's argument. Thank you.
Thank you. Thank you both. The next case is Beltran versus Commercial Building Maintenance Corp. You can proceed, sir.
May it please the court, John Guerreri on behalf of appellants. Good afternoon, your honors. So in this case in the lower court, the appellants moved for a default judgment. And on July 13th, 2021, the lower court dismissed this case pursuant to CPLR 3215C, saying that the appellants had abandoned the case because they had not moved within the one-year deadline to make a motion for.
Right, so would you consider that part a sua sponte order because it had not been asked for?
I would consider that part a sua sponte order.
So I'm going to ask you a procedural question. If that was a sua sponte order and not pursuant to a motion, didn't you, in order to bring an appeal of that ruling, have to make a motion before the trial court to ask them to either vacate that or do something with it so that we have jurisdiction, because it would otherwise be a motion on notice?
Well,
Procedural issue.
the appellants did make a motion to renew and re-argue after the lower court dismissed the action. I also think that.
But that's not that wasn't appealed, although I'm not even sure that could be appealed. But it's basically, isn't the law that you have to make a motion to vacate an ex parte order or a suit? No?
I'm not.
Not aware of that?
I'm not sure about that, Your Honor, but I also think you could interpret.
Well, I guess one of the reasons that becomes somewhat important is because part of the problem in this case, at least from the advantage of the lower court, was that there were two sequential motions for default, and they were riddled with procedural errors, just riddled with them according to her, right?
That's correct, Your Honor.
Right, so then the issue becomes up on appeal whether she was correct in her assessment about that. We don't even get to the merits about whether, and the merits concern the enforcement of a settlement agreement, correct?
Well, Your Honor, I would say that what we're appealing is is the lower court's order dismissing the case, which said that the appellants did not bring the motion basically within the deadline of 3215C.
That's the only thing you are appealing? You're not appealing her underlying decision to deny where she denied the default judgment that she had given you leave to renew because the second time around your record was insufficient? Was your record, let's start it this way. Let me make it simpler. Was your record sufficient for a default judgment in front of her?
Judge, the lower court ruled that basically because we submitted an attorney affirmation rather than an affidavit, that it was insufficient. I think that I think that the attorney affirmation was on behalf, because the court ruled that.
How did the attorney affirmation comply with 3215 of the CPLR? Don't you need an affidavit or a verified complaint?
I don't believe anything in the rules says that you need an affidavit. I think that an attorney affirmation could be sufficient under the circumstances where the attorneys had actual firsthand knowledge of the facts of the case, which in this case, the attorneys did have that exact knowledge, because this whole case is about a settlement agreement that this firm was a party to, and that this firm's clients were all parties to, that this firm negotiated and wrote and collected the payments.
That was explained in the subsequent motion to renew, which I don't believe is on appeal now, right?
Those exact issues are not on appeal, but we did in our motion to renew and re-argue, include an affidavit, which is something that we could easily do, is convert it to an affidavit. I also think that the firm itself is a party. That what the lower court's problem was is that if an attorney is a party to a case, then the attorney cannot give an affirmation, but really the firm was a party to the case, and an attorney from the firm gave an
You weren't a party
gave an
to the case,
affirmation.
you had an interest in the proceeds of the settlement.
That's correct, Your Honor. So what we're basically arguing here is that the court, by the time that it dismissed the case pursuant to 3215C, there was actually additional time. It was a premature dismissal because there was additional time under the statute pursuant to tolling to make the motion in the way that the court wanted it. And that's not to mention that the there's case law in this department that even if it's a faulty motion, that shows that you have not intended to abandon the case. And even if it's an unsuccessful motion, that shows you have not intended to abandon the case. So it's improper to dismiss the case.
Okay, thank you.
Thank you, Your Honor.
In the matter of Sarah D., you can proceed.
May it please the court, Hannah Whitebrook for the appellant. Good afternoon, your honors. This court should reverse the Bronx Family Court's special findings order insofar as it wrongfully denied one branch of the appellant's special findings motion. The family court declined to find that reunification with the appellant's father was not viable because his actions rose to the level of neglect, and instead stated that a finding that reunification with only one parent is sufficient to make the finding that it's not in the best interest for the appellant to return to her home country. This denial should be reversed, as appellant showed by a preponderance of the evidence that her father's actions rose to the level of neglect, and thus that she cannot reunify with him. Your honors, the court, after hearing the full testimony of the appellant and her guardian as to numerous instances of neglect by the appellant's father, failed to provide any justification or reasoning for the denial of the appellant, a vulnerable youth who testified clearly and credibly. Your honors, the neglect standard under New York Family Court Act 1012 F1A through B state that a neglected child is a child less than 18 years of age whose physical, mental, or emotional condition has been impaired as a result of the failure of the parent or other guardian to exercise a minimum degree of care. Neglect can be found in failure to supply the child with adequate food, clothing, shelter, education, or medical care.
Well, why is this finding necessary here? You have a finding with respect to the mother. Is that sufficient for you to go to immigration to get whatever legal status is necessary?
Your Honor, yes, it is sufficient to go forward with that, but our contention is that this appellant is a young, vulnerable child who testified for almost an hour about the neglect that she suffered under the hands of her father, and the family court, without any justification or reasoning, still denied her petition that she sought to find that neglect on the part of her father made reunification not viable. They ignored the fact that she testified about the physical beatings that she received on behalf of her father, as well as her father's wife.
But wasn't it really more the stepmother doing the beatings as opposed to the father?
No, Your Honor. She testified that both her stepmother and her father beat her. She said that oftentimes her stepmother enticed her father to beat her by making up lies or other things to get him angry at her. She testified that he beat her frequently with his hands and his belt, leaving marks and bruises on her hands and on her back. That he did this multiple times. She also testified that her stepmother beat her, and that is also, the father has a duty to protect her against the harm that he knew or should have known about as his daughter.
So can I ask a question? But the judge below did in fact grant your application for the appointment of her cousin as a guardian, as a special guardian, correct?
Correct.
Right, and that's the person she's been living with and who's been caring for her while she's been living in the United States.
Yes, Your Honor.
And has the guardian on her behalf, I know it's not in this record, made the application to immigration for a special visa status?
Yes, Your Honor, we have made the application.
And does this finding, one way or another, affect that application, since the reason that you brought the application in the family court was so that you could go and bring the special proceeding or the proceeding before immigration?
Yes, Your Honor, we brought the application both for the reasoning of making the special findings order, but as well as to protect the minor against further abuses or further neglect on the part of the father. So she's not precluded from making her special findings motions, but she was denied on the application and her petition where she requested that the court find that she did in fact suffer neglect under the hands of her father.
No, I understand what went on here, yeah.
Yes, but yes, she's not precluded from making the application, and it's not precluded if only one person is found to
So
not
this
be
is not really an attempt to bolster the application?
No, Your Honor.
You want a finding of neglect?
Yes, Your
On the
Honor.
other hand, the father did do a mitzvah, sending her to the cousin in the States, no?
Yes, Your Honor, he did send her to the United States, but that doesn't evidence any further active care. He actually abdicated his role as a father, further showing a finding of abandonment or neglect by sending someone else to care for her because he didn't want to anymore. She also stated that her father, despite the fact that she saw her mother be shot in front of her and die at only 5 years old, her father never provided care for her, never talked to her about it. And her father even stated that as a reason to send her to the United States in the care of her guardian, because he knew that she was doing well, but did not do anything further to talk to her about it, to provide any care for her, or to help her in any situation, which we maintain further bolsters a finding of neglect on the part of the father. In addition, the father, I'll rest. Thank you.
You could wrap up your last sentence.
In addition, the father neglected to provide medical care, and he's neglected to provide her any financial support or educational support in the last two and a half years since 2019.
Thank you.
Thank you, Your Honors.
The next case is Lynch versus New York City Civilian Complaint Review Board. You may proceed.
May it please the court, Matthew Daly for the appellants. There are three main issues on this appeal that I'm going to try to touch on today. The first is that the court should strike the Civilian Complaint Review Board's new definition of its jurisdictional predicate, abuse of authority, because it violates the CCRB's jurisdiction. The court should also strike that definition because it lacks a rational basis. The third issue is that the court should strike the CCRB's 2021 rules in their entirety because the CCRB violated statutes designed to ensure agency transparency. And I'll start with the jurisdictional issue. With its new definition of its jurisdictional predicate, abuse of authority, the CCRB disregarded 25 years of statutory meaning by expanding its powers in at least 4 ways.
Counsel, what's your support for your primary argument, which is that the CCRB does not have authority to investigate matters that may touch upon criminal conduct? The mere fact that they might not have done it before is not enough. So what is there in the statute or the legislative authority that prevents them from doing that?
Thank you for that question. The legislative history is the starting point for that exclusion of criminal conduct. So within the legislative history, there's a paragraph that identifies examples of things that are outside the CCRB's jurisdiction. One of them is corruption, which CCRB admits. The other one is criminal conduct, which gets referred to the DAs. And that's been the CCRB's practice. This is a new theory offered by the CCRB that it has jurisdiction over criminal acts, such as it's expressly defining its jurisdiction now to include purely criminal conduct, which is sexual assault and rape. And the CCRB's attempt to analogize to excessive force cases misses the mark because in an excessive force case, what the CCRB is doing is investigating and adjudicating whether there was a use of force that exceeded police procedures. It's not adjudicated.
But this kind of conduct, doesn't this go to misuse of, or would go to the misuse of police powers? And so therefore, wouldn't that be within the jurisdiction of the CCRB?
Well, so that takes me back to the jurisdictional point. The jurisdictional predicate is abuse of authority, and that term has limits. And with all due respect, and
But wait, I know you point to the legislative history. We don't get to the legislative history unless there is some ambiguity in the statute. Is there any ambiguity with respect to misuse of police powers?
as we cite in our papers, the Court of Appeals has said you start with the text of the statute, but the court is also required to look at the context and is also required to look at things like past practice, legislative history, context. So when you look at all of those things together, it's very clear, Your Honors, that abuse of authority has limits. And again, I come back to the point that even the CCRB admits you can't just look at the plain language of that term because the plain language would include corruption. But everybody agrees that corruption is outside the CCRB's jurisdiction. So you have to look at that term in the context of how it's been used over the past 25 years. And the law says past practice is given great weight in statutory interpretation. And on the criminal point, I just want to
go back to my first thing. That was past practice seems to be all you have to support this argument, because otherwise abuse of authority would cover these issues. So what do you have, again, beyond past practice to support the argument?
Well, it goes well beyond just past practice, Your Honor. And I think a very strong indicator of legislative intent here is that the CCRB's jurisdiction under the charter was revisited by the City Council and a Charter Revision Commission 3 times in the last 4 years. That's a very good indication of what the City Council intended with respect to CCRB's jurisdiction. And in 2021, the City Council specifically amended this phrase, abuse of authority, to include bias-based policing and racial profiling. Now, if abuse of authority were as broad as the CCRB claims, that charter amendment would have been completely unnecessary. And CCRB even admits that in the papers and said, well, this is just an advisory statement by the City Council. But under the law, under statutory interpretation, legislative amendments are required to have meaning. So there was a limit on this phrase, abuse of authority. Again, this was a 25-year past practice.
But not in the statute. It's just based on past practices. That's all you have, right?
Well, Your Honor,
the statute, it's difficult for me to comprehend why sexual misconduct wouldn't fall within the term abuse of authority.
Your Honor, I think where we're getting hung up is that the term abuse of authority as it's used in that statute is not just the dictionary definition of that term. Corruption is an example that the CCRB admits. Racial profiling and bias-based policing, the City Council had to specifically add that to CCRB's jurisdiction because abuse of authority is not as broad as the CCRB claims. The same goes for false statements. A Charter Revision Commission in 2019 considered this issue that false statements are outside CCRB's jurisdiction. They're the jurisdiction of the IAB, and the Charter Revision Commission said, we're going to carve out a very small segment of false statements, give that to CCRB, and that was then submitted to the voters. The voters approved that. And then CCRB a couple years later says, well, we're not satisfied with that, so we're going to use our own rules to expand our jurisdiction even broader to false official statements in any context. So it's not just, it's past practice, which this court is required to give credence to. It's legislative history, where you have corruption and criminal matters carved out. It's the recent charter amendments, where the City Council has spoken on the limits of abuse of authority and expanded them where it sees appropriate.
And is CCRB entitled to any deference in those determinations?
Under Court of Appeals authority with respect to a jurisdictional predicate, CCRB is not entitled to deference. And just on the criminal issue, I just want to note, our starting point is that sexual misconduct is not within CCRB's jurisdiction. And if you rule in our favor on that point, you don't even have to get to the criminal point. The criminal point is a subset within the sexual misconduct definition that the CCRB has adopted. Just quickly on the arbitrary and capricious point, the court doesn't need to go any farther than the fact that CCRB tried to justify this action in 2021 by relying on the record from the resolution in 2018 that this court struck down on procedural grounds. And the problem with that is that the landscape was very different in 2021 than it was in 2018. There were numerous changes made within the existing disciplinary system in response to requests for reform. And as a matter of law, an agency's failure to consider relevant evidence is arbitrary. So you don't even have to decide whether or not that evidence would have changed the result, but it's certainly relevant to the reasons that CCRB relied on for the rule change. And the failure to consider 3 years' worth of changes within the disciplinary system is certainly relevant information. And again, I just want to put in context here that CCRB was not filling a gap by suddenly taking jurisdiction over sexual misconduct and false statements. There are established bodies in this city that have been handling those matters since the CCRB's inception. So CCRB was not filling a gap, and those other bodies are already subject to oversight, such as the Commission to Combat Police Corruption and an independent panel on the disciplinary system of the NYPD. None of those bodies recommended that these types of complaints should be shifted to CCRB, which is a civilian body, which is not subject to any oversight. So you just have, the civilian CCRB unilaterally saying, we're going to take over this new power. We think it's not being done properly, in this city, so we're going to take
Counsel,
over.
is it really a shifting of oversight, or is it concurrent oversight?
Well, I think, and that's a good question, I think what CCRB is saying is they're going to take over their jurisdiction. So their 25-year practice has been when they receive sexual misconduct complaints or false statement complaints, they wouldn't handle those, they would refer those to the IAB. Now CCRB is saying, we're taking over that jurisdiction, so we're going to handle those complaints, and we're no longer going to refer those to the IAB. With that, I was going to address the statutory issues.
You'll have time in rebuttal to do that.
Okay, thank you, Your Honor.
Thank you. You may proceed, Counselor.
May it please the Court, Kevin Osowski on behalf of the CCRB. The CCRB serves an important role as an independent watchdog, ensuring that complaints of police misconduct against members of the public are
How do you
investigated.
respond to the argument that sexual misconduct based on past practices was never part of your jurisdiction, and now you're attempting to usurp that?
Yeah, so a couple points, Your Honor. There's nothing within the plain understanding of abuse of authority that would mean that sexual misconduct by police officers against members of the public would fall outside of the abuse of authority jurisdiction. And the charter limits CCRB's jurisdiction in several ways, but by limiting it to abuse of authority, discourtesy, offensive language, or excessive force, and allows CCRB to define what those mean within the scope of those categories, as well as the requirement that the complaint be abandoned.
What's the significance of the historical practice of CCRB not investigating sexual misconduct?
Yeah, so CCRB's decision to investigate sexual misconduct is something that has been developing since, as Your Honors know, since 2016. But that decision reflects a change in societal understandings about sexual misconduct, including the understanding that sexual misconduct is an abuse of power, and CCRB's growing understanding about the need for these kinds of investigations, as well as calls from the public to investigate.
Why is it appropriate to have a carve-out for corruption and not a carve-out for sexual misconduct? What's the distinction between them?
Yeah, so we distinguish the carve-out for corruption in a slightly different way, in that when we think about corruption, we think about officers engaging in conduct among one another, and this is the type of Serpico or Maldonado Commission style conspiracy, collusion, acting like a gang within the NYPD. CCRB doesn't have the jurisdiction to investigate that type of internal police misconduct. What it does have authority to do is investigate instances of police misconduct against members of the public that fall within that FADO jurisdiction, and that's...
The distinction you're making is between interactions with the public versus interactions within the police department itself.
Yeah, yes, it is that the crux of the conduct there, of a corruption corruption allegation, is that the police were doing something within the police, which is different from the
What about circumstances, for example, if, I don't know, someone, a civilian attempted to bribe and a bribe was accepted not to write a ticket? Would that be corruption that CCRB would be able to investigate because it involves the public?
So there would be several limits on that jurisdiction. One of them would be that you'd need a complaint from the member of the public, or complaint that this was a wrong against the member of the public, which I don't think presents in the example that you provided. And in addition, it would need to, CCRB would need to go through the kind of careful rulemaking, and if it were to exert its abuse of authority jurisdiction over some narrow set of corruption that specifically addressed interactions with the public, it would need to go through the kind of rulemaking and record building that it did here, where it heard, there are hundreds of pages of comments and testimony in the record, all showing that, that sexual misconduct and intentionally false statements by police officers against members of the public, again, against members of the public, are an abuse of authority and should fall within CCRB's jurisdiction. There were a couple other points that the counsel for the unions made that I'd like to respond to, including this idea that the charter amendments somehow inform CCRB's jurisdiction on sexual misconduct. I think it's important to note that when the charter amendment added bias-based policing and racial profiling to the charter, it did so as examples of types of abuse of authority that CCRB had authority over, and not an exclusive list of the types of abuse of authority that exist. It was also something that the Charter Commission acknowledged was clarifying the jurisdiction that CCRB had and giving CCRB a mandate to investigate those and a compulsion to investigate those kinds of complaints. And the amendment went beyond just including that in the racial profiling and bias-based policing in the definition. It expanded a whole set of authority that CCRB has to do look-back investigations about a pattern of police misconduct, which is exactly the kind of investigation that you would need to be able to prove up some of those allegations. Again, those are the kind of authority that doesn't apply to the context of internal corruption allegations. With respect to the legislative intent, counsel notes that there have been several amendments to the charter subsequently in the past several years, and CCRB's intention to investigate sexual misconduct is not something that is new. In fact, this is something that CCRB attempted to investigate in 2018 with a resolution that this court considered. And had the CCRB overstepped its bounds, the council has the ability, as is demonstrated by the charter amendments, to check CCRB's jurisdiction and amend the charter, limiting CCRB's authority. What the council has actually...
I don't really understand that argument. It didn't have the authority. What was it limiting? Say, like, we see in your mind that this is what you want to do and we're going to clip your wings in advance prophylactically?
Yeah, the council could have included in the charter the same kind of limit on CCRB's investigations that already existed in the charter with respect to criminal conduct, in that the charter limits CCRB from preventing or hindering investigation by law enforcement. If the council wanted to make a more explicit prohibition, it could have included that, but it didn't. And instead, the council's amendments to the charter clarify that it views CCRB's authority as encompassing more types of conduct, including bias-based policing, racial profiling, and false statements. I would also like to clarify the difference between the amendment pertaining to false statements and the false official statement rule revision is that the amendment pertains to comments made by police officers in the context of a CCRB investigation, which CCRB would not otherwise have jurisdiction over because it wasn't a complaint by a member of the public or expressing conduct against a member of the public. Rather, it was intentional misstatements made in the course of the CCRB investigation. Just 2 points on the remaining issues in this case. The petitioners are trying to invalidate all of CCRB's rulemaking here, but the allegations about open meeting law violations don't come close to supporting that, let alone supporting a finding by this court that Supreme Court abused its discretion in denying their open meetings law claim. And with respect to the statement of basis and purpose, there's no dispute in this case that CCRB followed the process required by CAPA and went through all of the procedures that are required before a rule becomes final. And throughout that process, the police unions have had an opportunity to comment and have their comments considered by CCRB prior to the promulgation of the rules. If there are no further questions, we rest on our papers.
Thank you. Rebuttal?
Thank you, Your Honors. I want to jump back to the jurisdictional point and the significance of the exclusion of corruption from the CCRB's jurisdiction. The city has now, for the first time, drawn this distinction that corruption is outside its jurisdiction because corruption involves internal matters, whereas the issues today, the city claims is different. And that's the first time we're hearing it. It's not found in any legislative history or in any portion of the record, and it just defies common sense. Of course, corruption affects the public, and you very well could have complaints from the public, similar to the example that Your Honor mentioned, complaints made with respect to police, allegations made, and those get referred to the IAB, just like the CCRB did with respect to sexual misconduct complaints and false statement complaints for 25 years. And I think what's very telling about the city's argument is counsel stated, well, the CCRB could take jurisdiction over corruption. They would just have to go through a rulemaking process to do that. And that just shows how far the CCRB is reaching. You have another matter, corruption, that everybody acknowledges is outside CCRB's jurisdiction, and that's been the practice for 25 years. And now the city is here arguing to say, well, we can just change that suddenly by going through a rulemaking process, and that will be brought within CCRB's jurisdiction as well. So what the city is arguing is abuse of authority is so broad that there's nothing outside the limits of CCRB's jurisdiction. And if that's the case, why did the city council include FADO in the charter in the first place? They could have just said CCRB has jurisdiction over all civilian complaints against police officers. FADO has to mean something, and past practice, recent charter amendments show that there are limits. And I do want to point out, Your Honors, and this is in our papers, there is also textual grounds within the charter itself for our argument, which is the fact that with respect to false statements, offensive language, the city council specifically identified things like gender-based offensive language that are within CCRB's jurisdiction, but they did not include gender-based acts within abuse of authority jurisdiction. So by including this within the offensive language prong and not including it in the abuse of authority prong, under statutory interpretation, it has to be deemed excluded from abuse of authority. And this has been the way it's worked in practice. So with respect to bias-based policing, since CCRB's inception—
You need to wrap up your argument, okay.
I'll just note that this was what was addressed with respect to the charter amendment, that the city council brought bias-based policing acts within CCRB's jurisdiction, took that away from the IAB, and that will rest on our papers and just refer the court as well to our arguments on the statutory points.
Thank you.
You very much.
Thank you both. All right, the next case for argument is Maldonado versus Baja.
May it please the court, I'm Ira Glauber, co-counsel for the appellant Maldonado. With me is Douglas Pick, who is counsel for Maldonado for the appellant from the outset. Your Honor, this is an appeal from the lower court's pre-answered dismissal of the key elements of a complaint. The claims were dismissed were for promissory estoppel, breach of contract, breach of the duty of good faith and fair dealing, and specific performance. The lower court, Your Honor, erroneously made findings of fact against the plaintiff, drew inferences against the plaintiff.
How do we deal with the fact, because this is based on documentary evidence, that the documents repeatedly stated that there would be no binding agreement unless it was signed by both parties, and it is undisputed in this case that the landlord never signed the amendment. How do we get past that, and why was it inappropriate for the court to say as a matter of law, based on the documentary evidence, there's no claim for breach of contract?
Easy, Your Honor. The law of the state of New York is where all of the material terms of an agreement are agreed to. It is binding. You look to all of the facts and the circumstances.
How do you deal with specifically having a provision here that no amendment will be enforceable? Because you're always looking at the intent of the parties. To determine whether it's a binding agreement, you have to determine the party's intent. And when the parties expressly state their intent, that it will not be binding until it's signed by both parties, and continually refer to that, how can the court say the intent is otherwise?
Well, Your Honor, there was the third amendment, which was a new lease. All of the terms of the new lease were agreed to. The landlord said, either sign it or you're out of here. So the landlord acknowledged that all of the terms had been agreed to. The tenant then signed the lease. There was nothing, Your Honor, which said that it all must be in writing. All that the lower court relied on were 2 early emails, which were preliminary. But, Your Honor,
Let's
there
go
were
back
2
to the
months
lease.
of negotiation.
I'm sorry, let's go back to the lease. Doesn't the lease provide that in order to be enforceable, it has to be signed by the party against whom it's offered? So in other words, in this case, the landlord.
Your Honor, the tenant surrendered the property. The tenant gave it back to the landlord, and then the landlord said, "Oh no, let's renegotiate a new lease." And they spent 2 months renegotiating a new lease. They agreed on all of the terms, and even the landlord's own agent turned to the landlord and said, "How come you're not signing this thing?" You have to look at all of the facts and the circumstances and not rely solely on that provision of the original lease, which had gone out the window. But, Your Honor, you're forgetting the promissory estoppel claim. Not only was there a claim for breach of contract, and where all the elements are agreed to.
We understand, but if there's no contract, listen for a minute, that a signature was required of the landlord in order to have a binding agreement. And if that's the case, then certainly the breach of contract, the covenant of fair dealing, and specific performance all fail away. So then you have promissory estoppel. But a key element of promissory estoppel is reliance. How can you rely on negotiations that didn't come to fruition in an enforceable contract in order to have promissory estoppel? The tenant knew here that there was no signature by the landlord.
No, Your Honor, the tenant knew that, because the landlord knew that all of the terms had been agreed to. The key one was the new rent.
But why does that make that promissory estoppel? Isn't the reliance on the side of the tenant? It's not what the landlord knew.
Your Honor,
It's
the allegations of the complaint have to be deemed to be true.
I am deeming them true.
Okay, and if they're deemed to be true, then the elements of promissory estoppel have been met. The reliance clearly was reasonable.
I don't see the reliance, and that's based on your complaint.
Okay,
right? You didn't have a signed where is the reliance?
The reliance, Your Honor, is they passed up 2 other premises that this.
But why is that different than any other kind of renewal lease negotiation? That's always true in the marketplace. If in fact what you're saying, your allegations make reliance where there otherwise is no lease, you're telling me that there's a promissory estoppel just because the tenant claims that they could otherwise have found other space? Really?
No, Your Honor.
Really? Wouldn't that create havoc in the marketplace?
Not at all, because this court has twice held, in Castellani versus Free, I believe that it is, that where the circumstances are so egregious that it is unconscionable landlord to rely on the terms of the written lease, where the damages are unconscionable.
You mean not the reliance is on the part of the tenant here?
Your Honor, they relied by passing up other opportunities. That's in the complaint, that there were at least two other spaces that they gave up. They incurred expenses. There were engineering, there were architectural, there were design fees. But, Your Honor, you have to look at the procedural phase that this was. This was a motion to dismiss in which all of the allegations have to be deemed to be true. And
I think we're aware. We're certainly aware of this standard.
But
except for documentary evidence that otherwise
Your Honor,
is
it's in re Hennel. That's what this case turns on. It's the Court of Appeals decision. This court twice held, both before Hennel and after Hennel, that on a motion to dismiss, claims for promissory estoppel should not be dismissed, because whether the circumstances are so egregious as to render it unconscionable to permit the defendant to invoke the statute of frauds are questions that should not be determined on the pleadings, but should await a full determination of the facts.
Thank you.
That's Castellani.
Thank you. All right, let's hear from your adversary.
May it please the court, Kevin Johnson for respondent. I'll briefly hit on what the court hit on during appellant's arguments, is that at the time these negotiations fell down regarding the alleged Third Amendment lease, the Second Amendment and First Amendment and lease were already binding on the properties, and those were not extinguished until August 31st, 2021. This hits on 2 points. First, in the breach of specific performance and the breach arguments. Nothing given by respondents or pled by respondents, by appellants, indicates that the parties had intended to override both the provisions in the initial lease between the parties that was still binding, or the First or Second Amendments, that any amendments are not binding on any party until executed by said party.
How about looking at all the circumstances, and all the circumstances that there are a series of negotiations, leases provided, signed by the tenant, wouldn't that be sufficient under the circumstances to at least?
Well, I think, there's a policy question here, is that should this exemption to the statute of frauds be carved out in the way that appellants would have us do, where the court has asked with the question, how close can a party get to signing before they're deemed to have signed it, despite any underlying contract that was still binding upon the parties or any other principles behind the statute of frauds? And respondents would have us believe that one email from a third party who is not empowered to bind the respondent was enough to get us past that threshold and carve out a new room for an exception to the statute of frauds. I think also this factual point goes to promissory estoppel and what damages were here. When negotiations shut down, the parties' reliance was that they were still under the same binding contract they were when they began negotiations over 2 months prior. And again, I think the point that the court hit upon is, how is this any different than any failed negotiation? At what point can parties freely negotiate with one another, knowing that they are maybe one email away from being stuck in a contract they haven't signed or agreed to be bound to yet? And I'd rest at this point on the papers. Any other questions?
Any questions, colleagues? We'll hear from your adversary in rebuttal.
The sole issue before the court is whether it was unconscionable for the court to dismiss the complaint. The rent went from $6,000 a month to $40,000 a month. The landlord had sued for $500,000. This was a small mom and pop tenant. And yet they were faced with the bill for $500,000. Clearly, that was unconscionable. And whether or not something is unconscionable is an issue of fact, according to what this court has held in the past, to be decided at trial, not based on the papers alone. Clearly, the agreement, you look at all of the facts and all of the circumstances, and it was reduced to writing. It was signed by the tenant. The landlord said, "I will sign it." And then he pulled a bait and switch, which is what the lower court had felt in sustaining the fraud cause of action. In addition to sustaining the fraud cause of action, the other claim should have been sustained as well, based on the unconscionable aspect of what went on here. Thank you.
Thank you. Thank you both. People versus Zamel, Washington. You may proceed.
Good afternoon, Your Honors. My name is Mark Zeno, and I represent Appellant Zamil Washington. May it please the Court. The people did not prove that Mr. Washington committed attempted first-degree murder. The people were required to prove that Mr. Washington had both the specific intent to kill complainant and that he came dangerously close to doing so. It proved neither of those. The evidence before the judge, showed an intent to rob a food delivery person, but not an intent to kill.
Well, didn't he repeatedly strike him with a very sharp object in his neck and his back and other parts of his body?
Yes, he did, Your Honor. But those stabs were to facilitate a robbery. They were the force used to commit first-degree robbery with a dangerous instrument.
When did he get the food?
I'm sorry?
He wanted to get the food from the.
Correct. In fact,
when did he get the food?
Yep, he got it in 2 stages. He got it initially after an initial stabbing. He continued to pursue the food delivery person until he got the remaining bag of food. Once he got that remaining bag of food, he stopped pursuing the food delivery person with the knife and fled.
How many times did he stab him?
At least 5 times, Your Honor. The question isn't whether this was a violent robbery. It was a violent robbery. He was convicted of first-degree robbery, which is a Class B violent felony offense for which he could have gotten a sentence of up to 25 years. The question is whether it additionally shows an intent to kill. There's nothing separate from those stabbings, which were a part of the robbery and for the purpose of the robbery, to show that intent to kill. We have the videotape. If you haven't seen it already, I'm sure you'll watch it. It shows that he was pursuing the food delivery person for the purpose of the robbery. Once he got the last bag of food from him, which incidentally he had ordered over the telephone, we know that the food delivery person was lured to the building for the purpose of this robbery. There's no reason showing an intent to kill. There are reasons showing an intent to rob.
So repeated stabbings, which I think a long knife, you could make a reasonable inference that there was an intent to kill.
Well, if there
in sensitive areas of the body, the back, the neck.
Not in this situation. If there weren't a robbery, Justice Singh, I'd agree with you that if somebody just out of the blue assaults someone with a knife, stabs them 4 or 5 times, then you wouldn't have an explanation for the stabbing. And you could say, well, he must have been trying to kill him. But here you have an explanation for the robbery. You have...
Couldn't the defendant have harbored the intent for both?
Can you repeat that, Your Honor?
Couldn't the defendant have harbored the intent to do both, to rob and to kill?
He could have harbored the intent to do both, but there was no proof that he intended to do both.
Well, the evidence, isn't there a reasonable view of the evidence that there was the intent to kill when you have a stabbing towards the back of the neck, you have the stabbing towards the upper back, you have him chasing him between floors, multiple stabbings. I think that's not reasonable?
No, it's not. Again, he was chasing him for the apparent purpose, and we're talking about beyond a reasonable doubt standard of proof here. He was chasing him and stabbing him for the apparent purpose of getting him to turn over the food that he had ordered. I mean, that's the purpose of this use of force. So there's not a reasonable view of the evidence that he was attempting to kill. Without the robbery, perhaps so, but you have a robbery which explains his actions. I'd like to turn to the ineffective assistance of counsel point. I think my time may run out, and I'll continue it on rebuttal. Defense counsel recognized the need to ask for lesser included offenses here. Unfortunately, he asked the court to charge itself on 4 lesser included offenses that were not cognizable under the law.
So what difference does it make since he was convicted of the top count anyway?
Well,
That would have got to any lesser charges.
well, a conviction of the top count does not render the failure to request a charge, a lesser charge, or the failure.
What, don't you have to show prejudice to show an effective counsel? So what prejudice could there be?
The prejudice is may I just answer that question?
You may.
The prejudice here, Your Honor, is there was a reasonable view of the evidence that he committed one of the lessers, and just as a jury might, if it were offered a lesser offense, choose to convict of the lesser, for the same reasons that I'm arguing here, that there was no proof of intent to kill. If the judge were offered lessers which did not require an intent to kill, it would have been a companion, a finding of attempted assault would have been a good companion for the jury for the court to find in addition to the robbery conviction. Thank you.
Thank you. You may proceed.
Good afternoon, Your Honors. John Hughes for the people. I'd like to start by responding to my adversary's weight and sufficiency claims. This attack started when this food delivery worker was waiting for an elevator, and defendant snuck up behind him with a knife, with a 5.5 inch long blade. And at this time, when he had ample opportunity to target his blow, he went straight for the back of this victim's neck. And then he continued to stab him 4 more times, including in the back of the head. In one of these stabs, when he stabbed the victim in the forearm, the blade went all the way through the victim's forearm, out on the other side. So frankly, of course, even a single stab wound to a vital area, like the neck, like the head, that alone can support an attempted murder conviction. But here you have not just that opening blow to the back of the neck, you have this additional repeated stabbing with very forceful blows. And that one was ample evidence to support the
Counsel, the fact that the force ended once the defendant had the food, what he wanted, doesn't that lend to the belief that his intent was to rob him, not to kill him?
Well, first of all, Your Honor, I think an intent to rob someone and an attempt to kill someone are not mutually exclusive. You can intend to do both. But second of all, too, after the initial stabbing attack, in the middle of it, the victim dropped almost everything he was carrying. And then he tried to retreat, leaving almost all of the food down on the ground. And still, even though the victim was only holding one small plastic bag, the defendant continued to chase him, continued stabbing him. And so I think the only reasonable inference here is that he intended to rob him, but he also intended to kill him as well. And now I'd like to turn to the ineffective assistance of counsel claims here.
I'm not sure if it's clear in the record, but was the defendant's face obscured?
No. He was unmasked, and you can see his face quite clearly in the surveillance video of this as well. And as this court noted with respect to the ineffective assistance of counsel claim, there simply can't have been any prejudice here. And that's because, in large part, because this was a bench trial, and the court convicted defendant of the attempted murder charge. And so therefore, the judge simply would never have even gotten to any lesser included offenses of that attempted murder charge. And I think it's also important to look at the judge's comments after the verdict here, too, because the judge really did not evince any kind of hesitation about defendant's guilt on the attempted murder charge. The court even noted that, the defendant's conduct was egregious and life-threatening. So it wasn't even, so I don't think it wasn't a close call in terms of the strength of the evidence here. And in addition, I would note, too, that defendant did not file a 440-10 motion here, in which case we could actually talk to his attorney and find out what his reasoning was for why he chose not to submit certain lesser included offenses. And I do think for some of the reasons we talked about in our brief, I think there are also ample, very legitimate strategic reasons why defense counsel may have simply consciously chosen not to submit these 2 specific offenses that defendant is now claiming that he should have. And if this court doesn't have any other questions, I'm happy to rest on my brief, and we ask that you affirm the judgment. Thank you.
Thank you.
Starting with the last point first, Your Honor, there is no need or reason for a 440 motion here. We have counsel requesting 4 different versions of first-degree assault and attempted first-degree assault, and not identifying the correct version of attempted first-degree assault that would have been applicable. There's no reason
Which one do you say would be applicable here?
Excuse me, Your Honor?
Which lesser offense would be applicable to
Well, there were 2 lesser offenses that would have been applicable. Attempted first-degree assault for disabling a member or organ of the body intentionally, and second-degree assault, attempted second-degree assault, intentionally causing physical injury. Both of those were available and could have been asked for. The fact that
Are those lessers, have they been recognized in the past as lesser included for attempted murder?
Well, certainly the attempted second-degree assault is a lesser. The people have not contested that it wasn't a lesser. The people do contest whether the version of attempted first-degree assault is a lesser. No court has considered the issue of whether it's a lesser or not, so there is no case law finding it to be a lesser or not to be a lesser, under the theory that if there is an intent to kill, there is necessarily an intent to disable a member of or organ of the body. It is necessarily a lesser included offense of attempted murder. Anytime you intend to you intend to kill someone and you attempt to kill someone, you necessarily intend the lesser offense of disabling a member of the body. And just one sentence, if I may, Your Honor.
You may.
The people contend that a different standard of prejudice applies because this was a bench trial and we can assume that the judge followed the law when it wasn't given the alternative of considering the lesser included offenses, but the Court of Appeals, in cases I've cited in my brief, hold bench trials to the same standard as jury trials. Thank you.
Thank you. Thank you. Thank you both. The next case is New York City Waterfront versus Puree. You may proceed.
Thank you, Your Honor. Good afternoon, and may it please the Court. I'm Greg Silbert for Appellants. The pre-loan fraud claim was dismissed on one single ground. The Court relied on documentary evidence outside the complaint that purported to show that the defendants were ready to prepay the loan before the maturity date. Now, here's the problem.
Is that the sole reason why the court dismissed it?
It is the sole reason why the Court dismissed that claim. Yes, it is, Your Honor. And the problem with that ground for dismissal is that everybody knew, including the defendants, that we were not able to accept prepayment of the loan before the maturity date because accepting prepayment could have jeopardized the immigration applications of the investors in the loan. So we could not accept that payment. And therefore, the documentary evidence that the Court relied on to dismiss that claim at best raises a disputed fact question. And we all know that disputed fact questions are not grounds to dismiss the case on the pleadings. If the defendants want to assert that argument and many other arguments that they have made in this appeal in a summary judgment motion, they're free to do that. But it is not a basis to dismiss the claim on the pleadings.
What about the ground that the allegations did not comply with that provision? It's a stated provision in the contract itself.
I'm sorry, that
I'm not being very clear. That the agreement itself talked about the projection, so it was an express term of the agreement, so it couldn't sustain the basis for a separate fraud claim.
That's
There were representations in the agreement itself about the financial projection.
That is an argument that the defendants have made on appeal. It's not a ground that the lower court relied on. Your Honor is correct that...
And why isn't it a valid argument, then?
Because the mere fact that the agreement says that the pro formas were prepared in good faith does not immunize the defendants from a pre-loan fraud claim.
But it says more than that. It says also the assumptions to be reasonably believed to be true at that time. Now we're coming back with hindsight and looking at it. So why shouldn't that provision trump that argument?
Because later on, the defendants admitted that the project did not have enough capital from the start and was over-leveraged from the start. So they later admitted that the facts were other than they represented before the formation of the contract to induce us to provide them the loan. And that admission shows that the pre-loan representation was false at the time they made it. At least that's what we've alleged. And at the pleading stage, that allegation is sufficient to take us forward, just like the false projections that were found to be sufficient by the Court of Appeals in CPC against the...
So essentially what you're arguing then is that defendants did not comply or didn't intend to comply with Section 310, right? Isn't that the nub of the argument?
There are two...
And so let me finish. Is that if that's the argument, then isn't that just breach of contract, that the borrower did not intend to perform the contract, and under our case law, that's not sufficient, right?
There are two independent wrongs that the defendants committed here, Your Honor. One of them is a breach of the contract. The other wrong they committed was falsely representing to us before we provided them the loan that they would be able to produce a certain amount of revenue, and earnings, which they knew they would not be able to produce because they knew at the time that the project was over-leveraged and undercapitalized. And it's that second wrong that is an independent fraud The mere fact that they then put into a contract that
Well, you would agree that rosy projections of future earnings is not usually a basis on which you could have a separate fraud action as opposed to a breach of contract. Isn't that the law?
Your Honor, there are two cases with facts exactly like this one that are very similar to this one, that hold that those kind of projections do support a fraud claim. The first one I mentioned is CPC against McKesson by the Court of Appeals. The second one is Merrill Lynch against Wise Metals. Justice Mazzarelli, you were on the panel of Merrill Lynch. Both are very similar cases. In CPC, the defendant made financial projections that turned out to be unreasonable because of facts that the defendant was alleged to have known at the time. Another pleadings case, dismissed on the pleadings, the Court of Appeals said, no, that's sufficient. In Merrill Lynch, the defendant, well, there was the plaintiff, but it was a cross-claim, said, well, we think we'll be able to place this debt on certain terms because there's a market for that kind of debt. The allegation was, no, really, you knew that you wouldn't be able to.
In this case, Counselor, what distinguishes the fraud claim from the breach of contract claim?
Well, the fraud claim is, there are two fraud claims. One is the pre-loan fraud claim, which was based on a representation, financial projections that were made to us prior to the formation of the contract. The other is a post-loan fraud claim. When the defendants were in default, we're now fast forward to 2018, they're in default. We have the right to exercise remedies. They say to us, don't do it because we are restructuring our lease. And once we restructure the lease, we will be able to pay you in 2019. We say, okay, we will not exercise the remedies. We rely on that representation. They are not able to pay us in 2019. Now, the sole ground that the court relied on to dismiss that claim was that it was supposedly duplicative of the contract claim. But in the Mann Advisors case, this court drew a very clear line between, on the one hand, representations about intent to perform, and on the other hand, representations about ability to perform. It held that representations about ability to perform are actionable as fraud, and that is clearly what we've alleged here.
So where in the seventh cause of action do you specifically allege that they made representations with respect to ability to perform?
So if you look at page 44 of the record, look at page I believe it's 20 and 35. At all of those points in the complaint, we allege that they say specifically, if you wait and you don't exercise remedies against us, which we had the right to do in 2018 because they were in default, they said, we are confident we will be able to pay you the loan in 2019. They say that in October of 2018. They say it again in November 2019. The specific words are, we will be able to pay you. That is about ability, not intent.
But don't they have to also have the knowledge or some kind of understanding that that's not true, or that they have no intention of, at the time, they have no intention in the future of fulfilling their obligation?
They do, Your Honor, for the fraud claims, not for the negligent misrepresentation claims, but as to both the
I was talking to you about the fraud claim before.
Yeah, yes, and as to both the pre-loan and the post-loan fraud claims, they do have that knowledge and understanding. With respect to pre-loan, the admission that the defendants made afterwards was that they were undercapitalized and over-leveraged from the beginning. And if you look at my friend's opposition brief, what they do when they argue there was no scienter or no falsity is they omit those words from the beginning. But the admission that the defendants made is they knew from the start that they hadn't put enough money in to operate the project successfully and they had taken out too much debt. Very different from what they told us. So that goes to the pre-loan claim. As to the post-loan claim, here's what we know at the pleading stage. We know in 2017, looking at the financial statements, we see that $1 million goes missing. Very shortly after that, they go into default. And we find out about...
If this is going to be a new thread of argument, I'm going to ask that you hold it for rebuttal.
Yes, Your Honor.
Okay, thank you.
May it please the court, Benjamin Jolson from Ackerman for the respondents. This case, Your Honors, is about a single-purpose entity that allegedly defaulted on a loan agreement. The business here closed like thousands of other businesses across the city. This is a space a restaurant that held large events like weddings, attracted tourists, and it went out of business. And the lender here is unsatisfied with the collateral that it willingly...
Can you address the argument with respect to Section 310?
I believe Your Honor is correct in that argument. They say that the financials will be provided in good faith, and there's no allegation. If there's an allegation that those were not provided in good faith, it's a breach of contract, and the court specifically held that well, with respect to the post-loan fraud claims, that they're duplicative of the breach of contract claims. So I disagree with counsel that the offer to prepay was the only basis for dismissal of this case. The trial judge...
Could you reach the same result without the offer to repay? Is it?
Yes, it's the same exact result. You can ignore that entirely, and the result is the same. The trial court specifically said the fraud and misrepresentation claims are baseless, and even if plaintiff had pleaded facts indicating a lack of intention or capacity to pay back the loan at the outset, they offered to repay. Let's not forget, this case is about a claim that the respondents failed to repay a loan and never intended to repay it. The fact that there is undisputed documentary evidence showing or requesting to prepay the loan, to pay the loan, and a week later it's rejected, we submit that that's dispositive. But you can ignore that because the appellants still have not alleged any of the other required elements of fraud, which needs to be pled with specificity. With regard to the pro formas and projections, the pre-loan allegations, those are purely predictions or opinion of what may happen in the future. There's been no falsity alleged. Where in the complaint is there anything alleged specifically? What was false? Why was it false? What input in those projections was incorrect at the time it was made? There's no allegation that there's any representation or misrepresentation regarding capitalization of the project or the leverage of the project. They're simply claiming you said you would have earned this amount of profit and you didn't reach it. That's not a fraud.
Well, what about your adversary's allegations that your clients said that they knew at the outset that they were undercapitalized and underleveraged?
Well, they didn't say they knew at the outset. They said it was, they subsequently apparently said it's undercapitalized and overleveraged from the beginning. That doesn't indicate that they knew that from the beginning. And regardless, there's no allegation of a representation or misrepresentation regarding those two items, capitalization and leverage. They don't allege that any of the respondents said, didn't tell them about a specific loan that was out on the property. They don't allege that there was a misrepresentation regarding labor costs, for example. They're simply saying, you said you would get, I think it's $26 million in revenue, and you didn't achieve it. And that relates directly to Sienter. There's no particularized factual assertion to support the inference of Sienter. Their complaint is the opposite. You don't need to look to documentary evidence or anything outside the pleadings. Look at their own complaint. Paragraph 10, the business was operating with significant success. Paragraph 10, the business was profitable for several years. Paragraph 59, the business earned between 15 and 18 million in gross annual revenue the last several years. Paragraph 59, this restaurant was one of the top 50 grossing independent restaurants in New York City. And paragraph 117, their own allegation that the business came close to meeting the projections with $2.3 million in EBITDA in 2016. That's the opposite of an inference of an intent to defraud. And you...
So can you address also the post-loan representations, and specifically your adversary's point here is in citing our cases, and members of this panel have been on that case, with Mann Advisors. Were there representations made post-loan with respect to the ability to perform?
No, the complaint specifically alleges that they have an intention to repay the loan or refinance the loan, which is a form of repaying the loan. They're saying we intend to comply with the loan agreement as a matter of law,
That is not fraud. And the other allegation is with respect to making operational changes to the restaurant, not a single allegation in the complaint that those operational changes were not made or were not intended to be made at the outset. Unless the court has any questions, we'll rest on our briefs.
Thank you.
Thank you.
Justice Singh, to your question about the breach of contract claim, we have a breach of contract claim against our contractual counterparty. But the people who gave us the pro formas were not at that time and were not ever the contractual counterparties. And we have a right to assert a fraud claim against them because, contrary to my friend's representation, they told us that they did know from the outset that the project was undercapitalized, or that is what our complaint alleges. And until they were able to put in evidence on summary judgment that shows otherwise, we can pursue these claims. Now, with respect to ability, that is exactly what they said, and it tracks exactly the language of the Mann advisor's case. Look at pages 20 and 35 of the complaint. What they said to us is, if you forbear on remedies because they were in default and allow them to restructure the lease, which they did restructure, they said, we are confident that we will be able to pay you. And then they said again in November of 2018, we expect we will be able to pay off the loan in full in 2019. Those representations go specifically to ability to perform, not intent to perform, and they are therefore not duplicative of the breach of contract claims under this court's decisions. But the duplicative holding was the sole holding that the lower court relied on to dismiss the post-loan fraud claim. Now, it did assert another ground with respect to the negligent misrepresentation claim. It said there was no special duty. That holding is wrong. With respect to the pre-loan negligent misrepresentation claim, this case is just like the Court of Appeals Kimmel against Schaefer case, which also involved projections. And the Court of Appeals there held at the pleading stage that where the defendant had unique and specialized knowledge about the economics of the project, where it knew that the plaintiff would be relying on the defendant's projections about the project, and the plaintiff did rely, that is a special relationship. And with respect to the post-loan fraud claim, all we need is privity. That's what the Court of Appeals held in Prudential. We certainly had that during the contract period in 2018 when they asserted those representations. So for both the pre-loan and the post-loan claims, the negligent misrepresentation claim should go forward.
Thank you.
Thank you.
Thank you both. People versus Maldonado. You may proceed.
Thank you. Good afternoon, Your Honors. My name is Hillary Dowling on behalf of Appellant Mr. Maldonado. We are asking this court to reduce both Mr. Maldonado's 10-year term of imprisonment and his 20-year term of post-release supervision. Mr. Maldonado was 31 years old at the time of his plea, and this was his first contact with the criminal justice system. As a first-time offender convicted of a Class B violent felony, he was eligible to receive a term of 5 years in prison instead of twice that.
Is the appeal waiver valid in this case?
It's our position that the appeal waiver is not valid.
Why is that?
I think that the most critical failure of the purported appeal waiver is that the court failed to explain the most critical feature of a waiver of appeal, that it is not an automatic consequence of pleading guilty. This was Mr. Maldonado's essentially first contact with the criminal justice system, first time in a courtroom taking a plea. And a person in that scenario.
I'm sorry to interrupt you. Did the defendant discuss the waiver with counsel?
The only statement with respect to that, and this is, I will just point out the sequence of events here. The court gave a very thorough colloquy with respect to the waiver of indictment.
delineating clearly that this was a right that Mr. Maldonado had and that he was asked to voluntarily relinquish as part of the plea agreement. The court then went on to discuss the trial rights that are automatically forfeited by the plea. And then after explaining the waiver of indictment, the court had Mr. Maldonado sign the written waiver without any explanation
There
whatsoever.
was no discussion with counsel with respect to signing the written waiver?
The only discussion happened after Boykin rights were discussed, and then the court discussed the waiver of the right to appeal. And very briefly, after offering that explanation, he said, "Did you discuss that with your attorney prior to signing it?" The court, however...
And what was the response?
Yes. The court, however, never...
Did the defendant state that he didn't understand the written waiver?
No, but I will note that he signed that written waiver before there was any discussion about the waiver of appeal. He signed that written waiver.
That's not uncommon, and we've held that that doesn't invalidate a waiver. So, but here the court actually specifically said to him, asked him, "Is that your signature on the bottom of the waiver of the right to appeal, above the line where it says defendant?" And the defendant said yes. And before that, the court had asked the defendant specifically, "Did you discuss she did say that, but it was in the context of a fairly extended discussion about the waiver. Did you discuss that with your attorney prior to signing it?" Meaning the appeal waiver that was in front of him that he was identifying. So what about that was misleading and confusing?
I'm not saying that particular portion was misleading and confusing. I'm saying that the written waiver does not save the oral colloquy that occurred in court. I think the important factors is that asking if he had discussed it with his attorney prior to signing it, even though he signed it before any on-the-record explanation about what it was, is that it was never ascertained on the record whether he read that written waiver or understood its contents.
Didn't the attorney also inform the court that the defendant understood the waiver?
I don't believe that the attorney was directly asked himself about the waiver of appeal. It was just a question about whether he had talked to his attorney about it in general. I see that I'm running out of time. If I could just say one more.
Actually, you see, you've run out of time, but
Right.
I'll give you another moment to make your final point.
I appreciate that. I just wanted to make the point, which I think is really very important, is that although the court's oral colloquy about the written waiver could be seen and thorough in some respects, the mere statement that the right to appeal is separate and distinct without explaining what it is separate and distinct from doesn't provide any guidance on the key issue that an appeal waiver, unlike trial rights, is not automatic, and that the right to appeal normally survives a guilty plea. All of those factors combined, considering it was Mr. Maldonado's first contact, I believe makes the appeal waiver invalid and unenforceable.
Thank you.
Thank you.
Let's hear from your adversary.
May it please the court, Daniel Young for the people. Your Honors, the sentence imposed, the 10-year determinate period of incarceration followed by 20 years post-release supervision, was entirely appropriate given that over the course of 2 weeks, defendant had raped his then 12-year-old stepdaughter multiple times.
Can you address the waiver, please?
Yes, the waiver of appeal was valid here. The court informed the defendant initially of the waiver of indictment, then he went to the defendant's Boykin rights, and then the court explained that he would also be waiving his right to appeal, which he described as a separate and distinct right. Further, the written waiver...
Counsel says that's not sufficient. There should have been more explanation.
Your Honor, given the sequencing and how it is separated from the Boykin trial rights that are automatically forfeited upon pleading guilty, that is sufficient to find that this waiver was valid. Furthermore, the written waiver more fully explains that it is a separate and distinct right from his Boykin trial rights that are normally forfeited, and that this is a condition of the plea agreement that he has reached with the people.
What do you say to counsel's argument that there's no evidence in the record that the defendant read the written waiver?
The record indicates that defendant did review this with the advice of counsel. While it does not explicitly say that he read the document, we can infer from the fact that he did look over the document and discussed it with counsel to mean that he read the document and understood the document. Otherwise, he would have raised any questions either with counsel and had those questions answered, or he would have raised those questions at the trial court. In fact, it's pure speculation that a defendant would say, yes, I've reviewed this with counsel, and then they just never read it. That's purely speculative at this point, and the record indicates that defendant did fully review the waiver of appeal with his counsel. So if your honors have no further questions, I would ask this court affirm the conviction.
Thank you.
Thank you.
All right, we'll hear some rebuttal.
In response to respondent's argument that it's speculation that he didn't read it, I think it's speculative that he did read it, particularly since he was asked to sign this document after he was explained the waiver of indictment and prosecution by SCI and signed that paperwork with the waiver of appeal included in that signing. There was nothing on the record of him and counsel having any kind of discussion once the waiver of appeal came up to indicate that...
Do you wish to say anything about why you believe the sentence is too harsh?
I'm sorry?
Do you wish to say anything about why you believe the sentence is too harsh?
Yes, I would. I would just note that he was eligible as a first-time felony offender for 5 years in prison.
We have a range. We have a range of 5 to what? 5 to 25?
Correct.
So he's eligible to get 25 too.
Absolutely. I think that under the circumstances of a first-time offender at the age of 31 who took responsibility and pled guilty prior to indictment, that it's more fair for him to receive towards the lower end, if not 5, then something less than
It's
double.
not one act here.
I understood.
Understood. You know, it's not one impetuous act. It's a course of conduct.
I understand that, Your Honor, and I'm not disputing the gravity of the defense. That's not in dispute here, but it is not the only factor that should be considered by the court. And with such a broad range, I think closer to the minimum would be appropriate.
Obviously, it wasn't because he didn't get the maximum.
Understood. I also know he didn't get the maximum, but I think under his circumstances, towards more than minimum is appropriate, particularly the 20 years post-release supervision. That is the absolute maximum. And I don't think that, I think that a term of 5 years or much less of the maximum of post-release supervision is more than enough to achieve the penological purposes of sentencing, particularly since he will be registering as a sex offender for the rest of his life and subject to those restrictions. Thank you.
Thank you. Thank you both. The next case for argument is the matter of Verdugo against Smiley and Smiley. You may proceed.
Thank you. Good afternoon. May it please the court. Andrew Wanger for the Fulham and a half defendants. This entire appeal is based on the lower court's decision was based on the false premise that a voluntary guardianship means that you're insane.
May I ask you a preliminary question, please?
Sure.
Has there been another matter here, another petition, or any other kind of proceeding which determined that your client was dismissed for cause and set some fee allocation?
No, that has not been held.
Hasn't been determined?
No. So, Supreme Court basically conflated insanity with incapacity. And insanity is...
Well, one could be a subset of the other, right? I mean, all the judge did was put it down for a hearing. There may be a tolling of the statute of limitations here, depending on whether the standard of insanity is met or not under the tolling statute, right?
Right, but except for the fact that nothing in this record, there's not one iota of evidence that establishes that there was an overall inability to function in society that prevented
This is
him.
a TBI case, right?
Correct.
2003 TBI?
Correct.
Weren't there findings back then about memory and cognitive deficits?
Yes, and we don't deny that. But insanity is a very high bar. It's unmistakable. I'm sorry.
Yeah, well, I know you're saying that, but it's true enough. You can be incapacitated and not be insane, but you can also be incapacitated and be insane, right? And lack of functioning, which requires a guardian, is some indicia that maybe you are insane, and therefore, what was wrong with the trial court saying, let's have a hearing?
Well, because this is summary judgment, and they had to lay bare all of their proof to establish that this man was insane. And when you look at the actual,
What's the difference? Where do you cross that line?
Well, so when you look at insanity, it's the inability to protect your legal rights. And the Guardian says that from 2003 to the present, this man was insane. But when you look at what he's done in those years, I mean, he retained 5 separate attorneys. He retained Smiley and Smiley, and then he retained the
I'm sorry, the perpetual retention of attorneys over and over again is not really an indicia of sanity.
Well, actually,
I just have to say that.
Indicia of insanity.
well, they were all for different purposes. Of course, he had separate workers' comp attorneys, and he pursued a workers' comp appeal. How can you say he couldn't protect his legal rights when he's pursuing an appeal without the Guardian on his own?
It's a matter to take a look at the hearing.
But
there's so many factual things that could be looked at differently in the context of this. I just, honestly, I personally don't really understand your argument, why as a matter of law you would prevail on this particular issue.
Well, if I could point to the Burgos case, where there was an affidavit from the plaintiff that said he had dementia. And in that case...
Signed under penalties of perjury?
I'm sorry?
Signed under penalties of perjury?
The case didn't, I don't think, mention that. But the issue in that case is exactly the issue here. In that case, the person who was supposedly insane engaged an attorney, signed authorizations, appeared at depositions, everything that we have here, and this court held...
Were there claims of TBI in that case, counsel?
There were claims of dementia and the person that was psychotic.
So this case, claims of TBI, cognitive deficits throughout the operative period.
Well, actually, if you look to I see my time is up, but if you look to the period before, his treating neuropsychiatrist said that he had gotten better. He didn't even need a guardian. And so if you don't need a guardian, that's a lesser burden than insanity. And there is no evidence.
At different periods of time. We also have a finding, or we have a determination in this court that he wasn't capable of contracting for the financing. He had no capacity to contract. So all right, that's not really a question. That's just an observation.
Actually, if I could
one last point, and then we're going to hear from you, our adversary.
So let me just address that. So basically, the Fulham defendants were excluded from the Peachtree trial. The Peachtree trial did not have access to the wealth of information. I mean, I have to apologize.
Again, all that does is sort of support the concept that we should have a hearing here, and you'll have full access to show what you show.
But right? it was the plaintiff's burden to show that at the time the cause of action accrued in 2007, that he was insane, that he was incapable of complete functioning society. And I would just like to throw in one last thing, and I'll
no,
wait
you could throw that in on rebuttal.
Rebuttal? Okay, thank you.
Okay, thank you. In fact, especially you asked for so much rebuttal. You'll have a lot of time.
Good afternoon. My name is Herbert Rodriguez from Schwartz, Golson, Campisi, and Cates. I think the court is on point when they're asking, isn't there an issue of fact here for a hearing? I'd like to highlight...
Well, can we actually address that? Was it error, or should the court have hold a hearing on the issue capacity, or should this really be an issue for trial? where the other side would be entitled to a jury trial on this question, because doesn't it sort of tie into their affirmative defense here?
That's a great point. Whether it's a hearing or a question really for the jury.
So you don't take any issue with it being a question for the jury as opposed to a question for the judge at a separate hearing?
True, I think it's an issue of fact regardless. I personally think it's for the jury, but I want to highlight, I would love for a jury to hear that an expert that Flomenhaft hired himself found Verdugo to have dementia from head trauma and other cognitive issues. That, by the way, her report is on page 2586 of the record, and in the findings on page 2610, Axis 1, it says dementia due to head trauma with behavioral disturbance.
Counsel.
Sorry. That alone, when counsel is saying there's no iota of evidence, I would say that's his own expert. So Flomenhaft, when he was prosecuting a case as a PI lawyer, said, well, Verdugo has a permanent, pervasive TBI claim, can't function, his expert supports that, but now that he's being sued for legal malpractice, it's, oh, well, you know what? He might have TBI, but he's not insane. There's an issue of fact. Now, with respect to them trying to then use this against us and say, well, your fee dispute, right? If we grant if summary judgment is granted, your fee dispute dies. I'm like, well, we have a stipulation, so ordered by the court, where they agreed to have a fee hearing at the conclusion of the case, where we preserved our rights to say there are claims and defenses. And so and I think this court is aware, given all the appeals that it's already decided and seen, that we have been arguing for 6 years that they're not entitled to a fee because they committed multiple acts of malfeasance. And so this is a way to say, hey, there's nothing to see here. Let's conceal all malfeasance and just throw this out as a matter of law, because in their mind, if Verdugo's malpractice claim is untimely, then the discharge for cause is untimely and my entire defense is untimely. I'm saying, wait a second. My fee dispute is based on the STIP, one, and the judiciary law, where it would create extremely bad precedent to say that, especially in a self-policing profession like attorneys, that an attorney would not be able to point to another attorney and say, hey, you did something wrong, malfeasance, you should not be entitled to a fee, and then say, well, we're going to attach a statute of limitations defense to that. That's not codified in the judiciary law, which governs fee disputes.
Is that an
It would
issue?
violate our
Really,
stick.
is that an issue we can address on this appeal? Is that asking for an advisory opinion with respect to the fee dispute? What Plama is asking for is dismissal of the petition based on dismissal of malpractice.
I like that position. That's an advisory that they haven't gotten there. But to the extent that they argue that res judicata and collateral estoppel attached to our fee dispute, I would respectfully disagree with that. But yes.
Well, but we have nothing to attach it to until there's a hearing in any event. Right?
I'm good with that. I'm good. I would be good with that position, Your Honor. Thank you.
Okay, thank you. Okay, rebuttal.
So first of all, we're not concealing anything. All the money that they say we apparently misappropriate, it's all been accounted for. The checks are in the record. But what I'd like to point to also is that
Again, that seems to be something that we don't really get to on this appeal.
Sure. So
okay.
I recognize that. But the other thing I want to say, though, is that this was a summary judgment motion, and we attached an affidavit from a board-certified psychiatrist who reviewed every single record in this case. This is a psychiatrist that works in the emergency room. He's an attending. He evaluates insanity all day long. Okay, and that affidavit is unrebutted, and it's not just I'm sorry.
There's other evidence. And I tried TBI cases. Those are really, really serious injury cases. There are affidavits of doctors discussing memory and cognitive loss here. Isn't that sufficient to raise an issue of fact with respect to capacity?
So that's the key word, is that it may raise a question of fact as to capacity, but we're talking about insanity here. And so not all TBIs are created equal. It has to rise, they have to show.
Insanity is ability to function in society. That's what insanity is. why don't the evidence that they present raise at least an issue of fact as to whether he, even back in 2007, had the ability to function in society?
Well, so two things to that is that it's not just an inability to function, it's an overall inability to function in society. And insanity,
As opposed to an inability to function in society?
an unmistakable overall. You can't do anything. And so insanity is not about what you can't do. It's about what you can do. And this man he protected his own legal rights. He pursued appeals. I mean, workers' comp found that he was able to work. He attended English classes. He managed his own money. He testified coherently for 3 hours at deposition. He answered questions about all sorts of different things. This man was totally aware of what his potential legal rights are. The other thing I'll point to is that we know that he understood his legal rights because he was keeping his doctor, Dr. Kuhn, apprised of the entire legal process with workers' comp. And we cite in our papers at page 16 all the different references, and there's more that we didn't actually reference, that Dr. Kuhn is noting in his record that all the information he's getting from Mr. Verdugo about, so if he can protect his legal rights by hiring attorneys, pursuing appeals, he also signed a divorce stipulation that was approved by the guardianship court. It didn't involve the guardian. He did it all on his own. Okay, it involved alimony, child support. I mean, how do you complete a whole legal process and say you can't protect your legal rights? The other thing I'll point to is that, in Burgos, and there's another case, Smulowitz, where they have dementia, I'm sure that those people had memory problems. I mean, it's implicit in those diagnoses, but a diagnosis is not the test. It's a functional test. And a man who's able to do all of these things is not insane. And they had to lay bare all of their proof. They had to come up with something to rebut the affidavit of Dr. Amsel.
All they had to do is create an issue of fact.
But Dr. Amsel, all the records that they referenced in support, which only really get to capacity, Dr. Amsel reviewed. And Dr. Amsel also said that there's something called the GAF, the Global Assessment of Functioning, which is how psychiatrists rate the seriousness of someone's condition. And he says that the McCarthy definition of insanity correlates to a 21 to a 30. That's unrebutted. And there's no evidence that Mr. Verdugo ever reached that low level. And actually, the evidence is that it was much higher. I just want to say
No. I gave you actually a lot of time, and certainly a lot of time on rebuttal. We have your briefs, and we understand your argument. So, no, you're done. We're going to go to our next case. Thank you very much. Todd English Enterprises versus Hudson Home.
Good afternoon, Your Honors. May it please the court. My name is Leanne Shofie, and I represent the appellant, Todd English. If any case warrants summary judgment, it is this one. Hudson admits to the material facts necessary for the court to grant summary judgment on the basis of the election of remedies doctrine. Hudson will throw out red herrings that the reasonableness of its termination.
But isn't that right, what you're getting to, that election of remedies gives the defendant a reasonable time to make an election?
Respectfully, Your Honor, the reasonable time only depends on whether or not performance was required. In this case, there was not a reasonable time as a matter of law because Hudson insisted that my client travel to Canada to sell more products in February of 2018. This is 4 years into the agreement. The Hudson insisted that my client sell more of its products in December of 2017.
When did the sexual harassment allegations surface?
The allegation surfaced the reporting was in October 2017.
So that was a few months before termination?
Yes, and thereafter.
So with respect to that allegation, didn't the defendant?
So after that, after Hudson was aware of those allegations, and there is no evidence in the record whatsoever that Hudson cared, after Hudson was aware of the allegations, it required Mr. English to travel to sell more products.
And wasn't there a problem with him traveling to Canada because of those allegations? And wasn't that part of the reason provided?
That was not a problem. Mr. English did travel to Canada as required in February of 2018. Hudson.
But that doesn't answer the question. My question is, wasn't the fact that he had trouble with his visa part of the reason given for terminating the contracts, the sexual abuse allegations and the resulting sequela, which included trouble getting a visa to go to Canada?
The record does not
reflect. Why doesn't that raise a factual issue?
No, Your Honor. Respectfully, two issues. One, the record does not reflect any issue with Mr. English obtaining the proper visa to travel to Canada in February 2018, which he did. No issue whatsoever. Simply a representation that English was unaware at the time that the visa was required. Mr. English retained immigration counsel, spending more money, performing more for Hudson at Hudson's behest, and appeared in Canada as he was scheduled. That's point number one.
There was no difficulty getting the visa?
No difficulty, none whatsoever.
Why did he hire counsel?
He hired counsel to assist with the visa.
So it sounds like there was difficulty, because generally going to Canada is pro forma, no?
An issue was raised by TSC inquiring, and so Mr. English deemed it prudent to retain counsel to ensure that he could obtain a visa to travel. The court may take judicial notice of Canada changing some of its immigration laws in 2018, and there was publicity about the fact that Americans who were indicted of DWIs could not travel into Canada, although that's not the facts of this case, and there was no indictment here. But out of an abundance of caution, my client performed under the agreement, went over and above and beyond to sell more products for Hudson. And Hudson insisted that my client do that, yet Hudson now seeks to hold it against my client that he performed under the agreement. The second point about that is, as a matter of law, the fact that my client engaged counsel to ensure that he could appear in Canada is not a violation of the agreement. As a matter of law, the plain terms of the agreement make clear that Mr. English was performing and doing his duty. He sold the products, and the fact that he needed to obtain a visa to travel to Canada, which Hudson asked of him.
Didn't your client also allegedly promote competitive cookware?
Allegedly, but Hudson admits that it was aware of it at the time, and that was a year and a half before Hudson terminated the agreement. Yes, Hudson cited that as one of the reasons. It only could cite to one time. The record is devoid of any other evidence. In fact, the record is devoid of any evidence of concern by Hudson of Mr. English's, as it deems in its conclusory affidavit, antics, et cetera. There's also no evidence in this record, none whatsoever, that the products that Mr. English was selling for Hudson were damaged in any way. Hudson made millions of dollars under this agreement, and in the final year of a nearly 5-year agreement, Hudson terminated right before over $500,000 was due of contractually guaranteed royalties. It's unfair to my client. There are no disputed issues of material fact. The few issues that Hudson attempts to create are irrelevant given the performance that Hudson insisted upon. Under this court's clear case
But the few issues you raise, wouldn't that be a violation of the contractual provision in terms of what the behavior was expected?
Can you repeat that, Your Honor?
The
Sorry.
issues raised, for example, with respect to sexual harassment, wouldn't that be a violation of the contract?
Respectfully, Your Honor, no, and I don't believe that the court needs to reach that because the election and remedies doctrine is very clear. Hudson knew about it. Hudson said nothing. Hudson made English perform in December of 2017 thereafter. Hudson made English perform in February of 2018 thereafter. So no, but were the court to look at the record and look at the agreement to make such a determination, it is clear that publicity about allegations in a complaint not against Mr. English that were later dropped, especially given that Hudson said nothing internally or externally, was insufficient under the agreement for termination.
Okay.
Thank you, Your Honor.
Thank you.
May it please the court, Gil Lazarus for the respondent, Hudson Home Group. The basic fact here is that what Mr. English bargained for was Hudson's right for immediate termination without notice.
Yeah, but counsel, there was no immediate termination. Your client knew what it got itself into when it entered into the contract because Mr. English's alleged bad acts go way back.
It was not obligated as a matter of...
But you still demanded performance, right? So isn't there a legitimate argument to be made that there was an election of remedies?
No.
Why?
Because Hudson was not obligated to terminate immediately. It said it may immediately terminate. The use of the word may clearly demonstrates that it was not, as a matter of contract, obligated to.
But you accept bad conduct. You accept bad conduct on the part of the contracting party, send them out to sell your cookware, and then ultimately you terminate after years of bad conduct. Is that a waiver?
In part, but what it misses is that the basis argued in the lower court for termination was the allegations of sexual harassment in 2017, the visa debacle in January of 2018. Those two events preceded the termination by no more than 4 months with respect to the Plaza allegations and less than 4 weeks with respect to the visa allegations. Hudson, therefore, under the election of remedies, clearly timely exercised its right of termination. And quite frankly, if it didn't, it's an issue of fact because the case law is clear. It's entitled to a reasonable period of time.
So are you conceding that the earlier bad acts, actually, there was an election of remedies, and it's really what occurred in 2017 and 2018?
What I will concede for purposes of the argument today is that the DUI in 2014 and the legal fees dispute in 2015 may, viewed in isolation, be precluded by the doctrine of the election of remedies, but it takes on an entirely different cast when viewed in 2018, and Hudson's customer says to Hudson in emails that are before this court's record, 742, 746 of the record, we have a problem here because of the Plaza Hotel. We have a problem here because of the DUI. So while those acts may have in isolation been subject to the election of remedies doctrine, when viewed in the aggregate 4 years later, that's a horse of a different color. And therefore, when Hudson made the determination in 2018 to terminate this agreement, it did so not based on those singular acts, but based on the aggregate acts. And that is an entirely different animal than with respect to those items viewed in isolation. As far as whether or not there was an issue with regard to Mr. English getting into Canada, the record's quite clear. There was a problem. There are multiple email communications with respect to Mr. English doing a test run in order to see if he could actually gain entry to the country. Not only did he contemplate doing a test run, he actually informed our customer that he was going to do the test run. To our embarrassment and chagrin, he then decides he's not going to do it. This is not exactly how Hudson wants to have the face of its product conduct itself before a major customer. And that's what happened. So to say that there wasn't an issue is really, quite frankly, to defy the facts.
Of course, if you have further questions, I'd be happy to answer them, but I think my brief adequately covers all these issues, so I'll rest on the brief unless the court has anything further to add.
Thank you.
Thank you, folks. Have a nice day.
You too. Okay. Go ahead, Counselor.
A few points. Going backwards, what counsel just pointed out, that the client was informed of Mr. English's, it was actually McGeaney, someone who doesn't work for either English or Hudson, that said that the chef was going to go on a trial run and then decided it wouldn't be prudent. With respect to that, the client responded, "Excellent," and that's at record 709 with a smiley face. The client was not concerned at all about the value of the products or that there was Mr. English was not a good representative of Hudson. The client wanted him in Canada selling the products, which he did. So that's point number one. Point number two, the fact that Mr. English was trying to get the visa to enter Canada to fulfill his contractual obligations is not a violation of the morality clause. It's anything but. He was doing his job. And I'll point out that if, in fact, Hudson was so worried about Mr. English's reputation at that point in time, in January of 2018, then Hudson could have terminated the agreement and said, "We don't want you to go to Canada. We don't want you to sell our products." Instead, and then the election of remedies doctrine arguably could be, there could be a dispute, but there's no dispute here because that's not what happened.
But just with that last point, the agreement's terminated February 2018. So there is a reasonable time, again, under the law, for the defendant to terminate. So doesn't that just raise an issue of fact?
It's not an issue of fact, respectfully, Your Honor, when there has been the passage of time, as the court noted in ESPN, is not relevant. What's relevant is whether there was performance required of the other party. That performance benefited Hudson. It was to the detriment of English, who retained counsel to go to Canada and to sell more products. And my client is still owed money under that agreement. It was a nearly 5-year agreement. Most of those guaranteed royalties were owed in that last year. It was 40 days before the end of contract year 3 and 10 months before the end of the entire agreement when Hudson canceled. And by the way, Hudson will be the first to say that it did compensate Mr. English for the actual sales royalties under the agreement for contract year 3. Yet, for some reason, it takes the position that Mr. English is not owed the guaranteed royalties. This case is very similar to Boscarol.
You're going to need to finish up your argument.
Thank you, Your Honor. It would be a waste of the court's time to try this case. Every single fact has been admitted to, every single material fact.
This doesn't sound like a wrap-up. Come on, you're on rebuttal, the light's on.
Thank you,
Okay, thank you.
Thank you, Your
Honestly,
Honor.
thank you all for your patience, for being the last case on the calendar.
I think the planet doesn't have a weakness. Nice to meet you.